Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have the fabulous Bill Porter, who has been practicing construction law for over 30 years. And today's topic is lien laws and other construction claim remedies. So without further ado, I'd like to introduce Mr. Bill Porter.
Thank you, Ariella. Yes, I've been practicing for over 30 years, so I know a little bit about this topic. I also chaired the committee of attorneys who rewrote all the laws that govern everything that we're going to be talking about today. So today I'm going to talk to you about what you can do to legally protect yourself so you get paid when you're working on a construction project as either a contractor, a subcontractor, or a material supplier in California. The tips that I'm going to give you today will help you to be first in line, and you'll be before others who don't do these things that we're going to be talking about today. In particular, I'm going to discuss the preliminary notice. There's the 4 releases and how to properly use them. They're the releases on progress payment and final payment, and sometimes they're conditional and sometimes they're unconditional. We'll discuss that. And we'll also, very importantly, discuss mechanics liens, stop payment notices, payment bond claims, and we'll even look in maybe a little bit into the Miller Act, which governs the federal projects. And we'll look at some forms, and we'll talk about procedures and deadlines. And let me note one thing, that although I'm going to tell you in many ways how to do this all yourself, please, of course, understand that SunRay Construction Solutions can do all these things for you. And I'm absolutely very happy to recommend them, and they do great work at a reasonable cost. So without further ado, let's proceed with the program here. Okay. As noted, I'm going to be talking to you, well, it's not on here, but the preliminary notice, mechanics lien, stop payment notice, payment bond claims, Miller Act claims, and forms and instructions. We'll go all over all those. And of course, these are for California. Every state is different. So first, we're going to talk about private works projects. Generally, the procedures that you follow depend on whether your project is a private works project, which is owned by private people on private property, or it's a public works project, which is generally on public property, although sometimes it's an issue when it's on private property with public funds, but many of those issues are labor issues rather than dealing with mechanics liens, stop payment notices, and bond claims. But anyway, as to private projects, let's first discuss the preliminary notice. Now, here's a form of preliminary notice. It's kind of broken into 2 parts. It's actually the blue part in the rectangle on the right goes under the one on the left. The type would just be too small. Let me say this too. This form and all the forms that we're going to discuss today, you can find on our website for free. And they're really easy to use because you just go on the screen and you can type into the blank spaces and then you just print it out. And our law firm is, our website is porterlaw.com. And when you get on the website, look for forms. Up on the upper right, you'll see a little section that says forms, and you can look at these forms we're going to discuss today and many other construction forms. And it's just a service to the public that the forms are there, and you can certainly use them. Okay, let's talk about this preliminary 20-day notice. Now, subject to a very few exceptions, serving the preliminary notice, or sometimes people call it a preliminary 20-day notice, is a prerequisite. You must do this in order to pursue a mechanics lien, a stop payment notice, or a payment bond claim, which we'll talk about in a little bit. So specifically, subcontractors and material suppliers to a project are required to serve this notice on the owner, and you can see here the owner, the direct contractor, and the construction lender, to the extent there is one. A lot of times there's not a construction lender. Okay, let me note a further distinction. Direct contractors, that's the people who have a contract directly with the owner of the property, are not required to serve a preliminary notice on the property owner in order to pursue a mechanics lien against the owner. However, note this, if there's a construction lender on the project, they would typically have a construction loan deed of trust recorded. Then the direct contractor does have to serve the notice on that lender. So to reiterate, if you are the direct contractor, generally you don't have to serve a preliminary notice on anybody unless there is a construction lender, in which case you should serve the preliminary notice, and you should serve it on the owner and the construction lender if there is a construction lender. Okay, let's talk about the procedures and the deadlines for serving the preliminary notice. Direct contractors, subs, and suppliers have to fill out and send this form on the screen within 20 days after first furnishing labor, materials, and equipment to the job site. It can be sent earlier, but it should be sometime between the time you have some type of contractual agreement and beginning work or supplying materials and before 20 days passes. You should serve it either by registered mail or certified mail return receipt requested, or you can use express mail or an overnight delivery by an express carrier like Federal Express or one of those. And you want to make sure it's to the correct addresses of the recipients that you're sending it to. Often you can find the correct address in your contract documents. There's also a case out there that when someone was given the incorrect information address, still later on the lien, stop notice, or bond claim would be good because you were given bad information by the owner of the GC. But I wouldn't rely on that too much. I would try to get the correct addresses for everyone. Okay, of course, before you send out the notice, always make a copy of the fully completed notice for your records. And then you want to save your receipt for certified mail or whatever you get from the express carrier. And then if someone signs for it, when that comes back, be sure to save that because it could be a long time later. Let's say if you had to go to court, that you would need those things to prove that you sent out your preliminary notice. You can also hand serve the preliminary notice. Now, I wouldn't recommend that because it's much more difficult to prove without that objective proof that you did so. I think the document itself is pretty self-explanatory. You fill in the blank spaces, the owner, the construction lender, and the direct contractor. You're hereby notified that you, the claimant, you describe the work, you give the address where you did the work, you state who you contracted with. It may be the direct contractor, it may be the owner, it may be a subcontractor. And then you give an estimate of the total price for the labor right here, and that would be your contract amount. That doesn't mean that later on, maybe your lien will be for a larger amount because of change orders and things like that. But at the time you fill this out, basically put in your contract amount, and then there's a proof of service affidavit that you have to swear that you served this thing in the mail, not regular mail, but you can do personal delivery right up here at the top, A. But I would suggest B, registered or certified mail or overnight delivery by an express carrier, okay, to the proper address. I wouldn't mess around with C, and then you sign it, and you get it out there, you make copies for yourself. Okay, that is the preliminary notice. Remember, you have to do this generally if you're going to, later on, if you don't get paid, to have a mechanics lien, a stop payment notice, or a bond claim. As the project progresses, there's 4 types of statutory waivers and releases that you might be given. I just want to talk to you quickly about which ones to use and at which time, okay? The first of the 4 is a conditional waiver and release on progress payment. You would only use this if a payment is promised or you got a check, but the check has not cleared the bank because it's conditional. The condition, which is referenced in the title here, and you can look up the code sections on these, like you can see here, it's 8132 if you want to read more about it, of the California Civil Code, which you can get online very easy. Anyway, the condition is, yeah, you're going to give me a check, but it hasn't cleared the bank. So I'm not waiving anything until that check clears. Okay, the next one is the unconditional waiver and release on progress payment. So it's a progress payment. One of the payments you get as the project goes along, and it's unconditional. And what this basically means is the check has cleared the bank. And so you waive all your claims that are going to be to a right here, you'll fill it in. It's a conditional. You put the information in here, all up here, self-explanatory. Who made the check, the amount of the check, the check is payable to. I've gone too far. Now I'm back on it. Except for disputed issues. Okay, let's go to the next one. Oh, hold on, I've gone too far. My apologies there. Let me go back. Okay, so the four of them, the unconditional release on progress payment when the check clears, and then on your final payment, this is when you've been paid everything on the project. You're going to waive your claims to the extent of your payment on the date that you send this out. And if there are disputed issues, you can leave it out right here. So you waive claims for everything as long as the check clears. And then the very final one is the unconditional waiver and release on final payment. It's unconditional because your check cleared, but down here, you can still leave.
Bill, I'm not sure if you can hear me, but I believe there was an intermittent issue. Can you hear me?
You to get paid, then what you want to do is going to be a mechanics lien. The mechanics lien is a wonderful and powerful tool because what it does, it allows you as a client where you did the work and get paid from the proceeds of the sale of the property. And as you can imagine, it's a very powerful tool against the owner of the property. And so it can be done to get around it. Someone could bond around it. You would get a mechanics lien release bond, but all that does is it substitutes the bond and all the aspects date on that stamp when you have it. It's going to be the date that it was recorded. What I want to note, very important, is that from the date that you will see, we're going to have 90 days, either 90 calendar days, everything is on this is calendar days. You're going to have 90 calendar days to either get this worked out and get paid, or you're going to have to file a lawsuit to foreclose on the mechanics lien. So those are your two choices. If you go beyond the 90 days, then your lien will expire and the other party could force you through the courts to release it because it's expired. Okay, it's fairly self-explanatory. You fill out the same basic information as on the previous form on the preliminary notice, and you state the amount of money that you got paid. There's something here about an interest rate. If your contract states an interest rate, then you would put it. Otherwise, I would say you should feel free because of California laws on interest to put in 10% per annum because there's a code section on that that would allow that. Okay, and then after that, the form itself, in looking at the form, this one here, which is on our website, is 3 pages. The front page is the most important. The next page, you have to have this language in your mechanics lien, and then the third page, again, is a proof of service. And I will note one thing, you have a proof of service here that you would serve on the owner of the property. And then you have an alternative proof of service here that if you couldn't reach them, you can serve this one on either the construction lender and or the original contractor. Okay, what I would do if you had to do this yourself and you weren't using the services of SunRay to do this for you, is that I would serve both. I would serve it on the owner here, and I would serve it over here on the construction lender and the original contractor if there was one. That way, you know, it's kind of a sleep at night thing, and you feel better that you haven't missed something. All right. Let me go back here and talk about this in some other ways here. Okay. There are timelines that you have to serve these within or have them recorded. Let me know one thing. If you intentionally inflate your mechanics lien for work that you didn't do, there's a punishment in the law, and that is that the entire mechanics lien will be dismissed by the court. So be careful to put in good faith the amount that you think is appropriate. Let's talk about the timelines for recording your mechanics lien. If there's a valid notice of completion or a notice of cessation recorded on the project, then there are timelines, and then there's a different timeline if there's no notice of completion or notice of cessation. And then there's a little distinction between whether you're a direct contractor, which has a contract with the owner, or a sub or a supplier. So with direct contractors, if there's a valid notice of completion recorded on the project, then the direct contractor will have 60 days after the notice of completion or notice of cessation was recorded before they must record their mechanics lien in order for it to be timely. Okay, let me mention something about notices of completion, notices of cessation. And this is often violated by the owner. So if the owner says, oh, hey, you can't file a mechanics lien because there's a notice of completion, but note this, a notice of completion is valid only if it's recorded within 15 days after actual completion of a work of improvement. I'll tell you, half the notices of completion I see are not valid because they're not recorded within that 15-day period. And when you're getting ready to record your mechanics lien, you don't know if the notice of completion is valid or not valid. So I have to say, you just need to record the mechanics lien, and then later on, if someone raises an issue, you'll figure out whether the notice of completion is valid or not valid. I would say, I don't think I'd be wrong to say half of notices of completion themselves are not timely. And if they're not timely, you disregard them. There's also something called a notice of cessation, and that's when a project never does conclude, but it stops. And then you can record a notice of cessation. It stops before completion. But note this, a notice of cessation can only be recorded, a valid one that is, after work on the project stopped for a continuous period of 30 days. Okay? Now with subs and suppliers, it's different than with the direct contractor. If you're a sub or a supplier and there's a valid notice of completion, notice of cessation, then you are going to have only 30 days to record your mechanics lien after that valid notice of completion or notice of cessation. Now, there's another situation that develops here on when you record your mechanics lien. A lot of times there is no notice of completion or notice of cessation. So in those cases, what you have to do is you're going to have to serve, whether you're the direct contractor, a sub, or a supplier, you're going to have to serve your mechanics lien, or actually record it within 90 days after there is a actual completion of the project. Now, my recommendation is don't get close to that 90 days because you may be off a little bit. If it looks like you've tried and tried to get payment and it's not happening, then you may not be sure when actual completion was. So you probably want to get moving and record your mechanics lien. And note this, after you record your mechanics lien, you have 90 more days to file a lawsuit or get it released. So it's quite a bit of time to get things worked out. I should note also that with private projects, except for little residential projects of less than 5 units, the owner of the direct contractor is supposed to let you know notice of cessation. If they don't let you know that, then you're going to have 90 days regardless of whether one was recorded or not recorded. It's just one of those distinctions that are good to mention. Okay. Often it's difficult to tell, well, if there's no notice of completion, and even if I don't know when was completion, to say whether they're within 10 days or 30 days for notice of cessation, then when is completion? So here's some options to look at on whether or not completion has actually occurred. One, whether there can be no dispute that all the work on the project is completed. Okay, then there's actual completion. But also, if work stops and the owner or the owner's agent occupies the work of improvement, like let's say it's a McDonald's restaurant and they've had their grand opening, well then I would say that constitutes completion. Or a third way is if there's a cessation of labor for 60 continuous days, even though it's not completed, then you can say that equals a completion, and then you have 90 days to record your lien. So remember, either actual completion or work stops and they occupy it, or there's a notice of cessation, or I'm sorry, there's a cessation of labor for 60 continuous days, then that equals completion, and you have 90 days to record your lien, and then after that, 90 more days to file your lawsuit. So those are the deadlines. The procedure for recording your lien is you go down to the county recorder's office, okay? And you would record it there in the county recorder's office where the property where you worked is located, not where, let's say, the contractor, the owner, or someone's office is, but it's actually the county where the property is that you worked on. Okay, you would record it there, and then you would send out, according to that proof of service, which is on the screen still, you would send it out to either the owner or the construction lender in the original contract. You'd send them a copy of what you sent to the county recorder's office. Now, as I noted, you have to file your lawsuit within 90 days after that. There is a way to extend that 90-day deadline. It's called a notice of credit. I mean, if you ever get to that point, maybe just give me a call and we can talk about it, and we'll just call it an extension of the seminar. But there's this notice of credit, but the owner of the property would have to sign it before a notary, and then it would have to be recorded at the county recorder's office, and it's limited in duration. But that's a rare thing, but just know that it is possible to extend the lawsuit deadline. Okay, the next topic is different from the mechanics lien, where you get to sell the property. The next one is the stop payment notice, and what this does is you put in your claim, and it'll stop money from flowing either from the owner to the direct contractor, or sometimes from the lender to the direct contractor. Okay, and so what happens is that when you do a stop payment notice, they will hold this money until it's clear that all the deadlines have passed for you to make a lawsuit claim on that stop payment notice. And let me mention this. These remedies are not exclusive of each other. You can do a mechanics lien, and then for the same amount, you can do a stop payment notice, and then for the same amount, you can do a payment bond claim. You can do all three of them. So you really have a huge impact on the project and the flow of money. In the end, you don't get paid three times. It gets worked out, and you get paid once on the amount that you're owed, and then possibly if there's attorney fees, you might get some attorney fees. If there's an attorney fee clause or a statute that would allow you to get attorney fees. Anyway, the stop payment notice is a wonderful tool that you can use. And let me mention, since we're on private works, that there's a distinction on whether your stop payment notice, and there's the form right there. You can see it's similar to the other ones. Okay, the owner, the direct contractor, and the construction lender. And then there's a verification here that it is true and that you've served it, etc., on these people who are right here. Okay, but there's a distinction to draw on private works. If the project has a construction lender, then you're going to have to go to a bond company, or it would be recommended for sure that you go to a bond company and bond the stop payment notice. Because if there's a construction lender and you're wanting to get the money from the construction lender and there's no bond on the stop payment notice, and it's a stop payment notice bond, then the construction lender is going to ignore your stop payment notice. They'll just ignore it. They won't tell you, oh, hey, you need a bond. So that's going to be up to you, because they're not in the habit of telling people how to come and take their money. They're going to leave that to you. So be sure, if there's a construction lender, to get a stop payment notice bond. And then what will happen is that either the owner, if they have the money, or the lender, if they have the money, they're going to withhold 125% of the amount of your claim from the general contractor. And you might have your stop payment notice, and then you don't pay someone because you didn't get paid. Like, let's say you're a sub and your supplier doesn't get paid. They'll have another stop payment notice if they pursue their remedies, and it really starts to become a problem for the direct contractor, because a lot of more money is being held up than is actually owed. And it's the same thing with the mechanics lien. They can overlap too, because contractors and subcontractors and suppliers at all levels can do these same things. So it's kind of a cumulative type thing. So let me talk about the procedure to give this stop payment notice. You fill out this form. You can see that you give it to the owner and the direct contractor and the construction lender, if there is. You can also give it to the owner's architect, okay, and that may be sufficient for services on the owner if you cannot reach the owner. But be sure when you serve it to use, like before, an express carrier, an overnight express carrier, or registered or certified mail, so that you're able to preserve a copy of the proof that you served the thing. Okay, and when you serve the construction lender, if there is one, you're going to be required to serve the manager or other responsible officer or person at the branch of the lender where the funds are being held. So if it's a local branch of a bank, you would serve that local branch. You wouldn't serve like the world headquarters of Bank of America. Just the local branches where you'll be serving. Now, like with liens, there is a deadline on serving your stop payment notice that has to be followed. So if there's a valid notice of completion or notice of cessation, and we talked about when they're valid based on their timeliness already, then a sub or a supplier has only 30 days from the date the notice was recorded or before a stop payment notice must be served. Okay, and it's the same rules as before. Let's say that there is no notice of completion. Then you figure, okay, was it actually completed? Have they occupied the property? Was there no work for a continuous period of 60 days, even though it didn't finish? And if that is the case, then your time period for giving your stop payment notice expires 90 days after any of those events that are showing that it's completed, even though there was no notice of completion. So you have some time to get this worked out in that case. But just notice, if there's a notice of completion, notice of cessation, then get the thing done within 30 days. Get your stop payment notice served within 30 days. And if there's none, you have 90 days, all right? Those are the deadlines on stop payment notices. But then that's on serving. You also have a lawsuit deadline, okay? So if you're gonna sue somebody for not paying you, let me say you're gonna sue them definitely for breach of contract because they haven't paid you. If you recorded a lien, you're gonna have a claim on the mechanics lien. You're gonna sue on that, which is 90 days after you recorded your mechanics lien. We already discussed that. On a stop payment notice, you can file your lawsuit anytime after you wait 10 days from serving your stop payment notice, but no later than 90 days after the project, after the last day within which stop payment notices must be served, which is either, sorry to have so many levels of deadlines here, but let me do it from the end of a project. A project ends and there's a notice of completion, then you have 30 days plus 90 days to file your lawsuit. If the project ends and there's no notice of completion, then you have to figure out when it ended and then have 90 days to to serve your stop payment notice, and then 90 more days to file your lawsuit, okay? Anyway, those are the deadlines on that. You can find these, all these deadlines in the Civil Code in the 8,000 series, like 8,000 to like 8,500, in that range, okay? All right, and then the third remedy that we're going to talk about here, very important, is the payment bond claim. Now, there's not always a payment bond on private projects. Sometimes there is, sometimes there isn't. But if there is a payment bond, then there's a form for it. It's on our website, and you can do it. Now, the payment bond deadline is generally pretty far out there. If you're going to serve this payment bond notice, you should do it within 15 days after notice of completion. And if there's no notice of completion, then probably within 75 days of completion. A lot of times, though, it's not even necessary. I think generally, though, it's good to put people on notice, but I have known in many cases, and there's some distinctions in the law on this, where people just go directly to the payment bond as part of their lawsuit, which would include breach of contract, mechanics lien, stop payment notice, and payment bond, if there is one, okay? You serve the payment bond notice on the bond principal, you can see here, and that would be generally the owner, the direct contractor, or sub. Usually it's the direct contractor, and then the surety, okay, which is the bond company that issued the bond. And then generally your lawsuit is a little bit longer away. It's going to be 6 months after completion of the work of improvement. And that is with a recorded payment bond. Okay? If it's not recorded, it could be up to 4 years, but of course, why do you want to wait 4 years to file a lawsuit? You want to get your money. Okay? So those are the basic rules on private works. Now, in public works, I'm going to go through it very quickly because there's so many similarities. All right? So with public works projects, there's a preliminary notice here. Now, the preliminary notice is basically the same as with private works projects in many regards. The main difference, though, is if you are the direct contractor or the prime contractor on the project, you don't need to serve you don't generally, with the private works, you don't need to serve a preliminary notice unless there's a lender. Okay, with private works. With public works, the direct contractor is not going to need to serve a preliminary notice at all. Now, an interesting distinction is with public works, the first tier sub also doesn't have to serve a preliminary notice. And people go, what? But you can see these code sections at the top, and if you want to look them up, you would come to the same conclusion. Now, best practices say, though, the first tier subs should serve a preliminary notice anyway. But if you didn't, it's not the end of the world, because you should still, with public works, be able to go forward with your claims. Okay, that's the preliminary notice. Okay, then there's the statutory waivers and releases. We already discussed those, and they're the same. They're the 4 types. They're conditional and unconditional on progress payment, and conditional and unconditional on final payment. The main thing is never send a unconditional waiver unless the check has cleared. Okay, I know that there's some programs out there like Textura that don't follow this, and I think they're wrong legally, but I do believe that Textura is a program that protects your rights, and they will hold, as I understand it, a unconditional release until you actually do receive your payment, which comes from them anyway, or through them. So they're the same as with private works, using these statutory waivers and releases. The stop payment notice. We talked about the stop payment notice, and with private works, it was noted that you have to get a bond for your private work stop payment notice if there's a construction lender. Otherwise, you don't. Now, with public works, you never need to bond for a public works stop payment notice. You just serve it as is indicated on the form, which is on our website and is the same as the one we already saw. Okay, and then with public works on the payment bond, now I noted earlier with private works that there's not that often a payment bond, but there's almost always a payment bond on public works projects. So that is available out there. And again, you can use all these remedies. With private, you can use the mechanics lien or stop payment notice or payment bond claim. And with public works, you can use the, of course, just the regular breach of contract as with private, but you also will be using the stop payment notice without a bond, and you'll be using the payment bond. Both are available, and you can avail yourself of both remedies with public works. Now, there's another type of public works I'm going to go over briefly. Now, you have the PowerPoint presentation. I don't know how long this is active for, but there's quite a bit of a discussion here. I would like to call your attention to one thing. Now, with federal public works projects, everything we discussed before isn't going to work because it doesn't apply. You're going to be going under this thing that's called the Miller Act, okay? And there are limitations with this. It's like a payment bond, but it has all different rules. And going up into this diagram that I have here, this is really important. If you're going to do a public works project, you see this dashed line here? You're always going to want to make sure that you're above that line, because let's say a dispute develops. Let's say that you're the first tier sub. That's great. You can do a claim against the original contractor for breach of contract, and you can make a claim on the Miller Act bond. Or if you're a material supplier to the original contractor, or if you're a material supplier to a first tier sub, or you're the first tier subs, you're their subcontractor, you're a second tier sub. Now, all these people up here can sue whoever owes them the money, and sue the Miller Act bond company and get their money from that. The danger is being below this dotted line here, this dashed line. None of these people down here in this diagram can make a claim against the Miller Act bond. So it would be terrible if you were this material supplier and this one above you went bankrupt, or you were a sub or a material supplier to the second tier sub and they went bankrupt, because you would not be able to make a Miller Act claim. All you'd be able to do basically is put in a claim against this person's bankruptcy, and maybe you'd get pennies on the dollar years later. And so you should avoid being down here unless you know the person above you has done a lot of federal projects. They know what they're doing, and that they're not going to disappear at the end of the job. Okay, there are some other distinction. Let's talk about A, B, and C real quick. If you're the direct contractor, you had to pay for the Miller Act bond. You can't make a claim on it. All right. If you furnished work or materials under a direct contract with the direct contractor, then you sue them, the direct contractor, for breach of contract. You sue the surety on the Miller Act bond, and you have to file your lawsuit in federal court, by the way, no later than 1 year from the date that you last furnished work or materials on the project. And that's not when the project ends. It's when you last furnished work or materials on the project, no later than a year. Now, then the third is, if you have a direct contract with the first tier sub, then yeah, you sue the sub for breach of contract, and you can sue the surety on the Miller Act bond. But there's an additional rule. You have to serve a 90-day notice on the direct contractor no later than 90 days after you last furnished work or materials to the project. There's a form on our website. I'm not sure if it's on here. No, it isn't. Let me go back here and we'll be just about done. But on our website, there's a Miller Act form for making claims on federal public works projects. And then again, you have to file a lawsuit against whoever owes you the money, plus against the Miller Act bond, within 1 year after you furnished work or materials to the project. And then if you're below that black dotted line, you're here. You only sue whoever you had a contract with, and you can't make any claim on the Miller Act bond. Okay, it's brief information, but in addition to the forms on our website, there's lots of articles on this stuff. And of course, as I mentioned, Ariella and SunRay Construction can do all these things for you. So this is kind of a do-it-yourself primer, and I know I went kind of fast. If anybody has any questions on this, either now or in weeks to come, and they want to contact me by email or giving me a call, I can help you out, and we'll just consider it an extension of the seminar. And so with that, Ariella, I'll hand it on over to you.
Wonderful. Thank you so much. You were absolutely fabulous. If anyone does have any specific questions, on the right-hand side of your GoToWebinar, you can ask a question, and Bill, of course, would be happy to answer, but please, there's his contact details, and please feel free to reach out to him with any additional questions. So,
yeah, absolutely.
So far,
if anybody has any questions at all, just give me a buzz or email me.
Such a thorough job that everyone is officially a California-Lien law guru, Bill.
Well, I enjoyed presenting for you today, Ariella, and for the audience, and I'll be happy to return when you might need help on this or any other topics that have to do with California construction law.
Wonderful. And we have 3 more webinars coming up this year, and we'll send out those invites for the next few webinars. So to everyone, thank you very much. Of course, to our wonderful presenter, Bill, thank you very much. Wonderful job, and I wish everyone a sunny day.
Thank you. Bye-bye, everyone.